Hello, everyone. Welcome to a conversation between Rochelle Golden and myself. For those of you who probably are aware, my name is Glenn Ingram. I kind of go by the accessibility guy because I specialize in web accessibility. And I've invited Rochelle on this live stream so that we can talk about accessibility for people who maybe aren't familiar with it, maybe have some misperceptions, so that as business owners, you can know what you're liable for, what you're responsible for, and kind of what's going on in California and across the country with regards to ADA website compliance. Thanks for joining us, Rochelle. Would you tell everyone a little bit about yourself?
Yeah. Hi, Glenn. Thanks so much for having me. My name's Rochelle Golden, like Glenn said, and I own Golden Law APC. And basically, what I do is assist businesses in proactive accessibility compliance in the web space. So that's looking at websites to make sure that they're compliant with the WCAG guidelines, which are the accessibility guidelines. And also, I'm a defense litigator, so I've no problem taking these cases on in a defense litigation standpoint if they warrant that, if they're defensible cases, and taking them to trial if I need to. So I work in the digital environment as well as the built environment for construction related proactive consulting, such as ramps, parking spaces, that sort of thing, as well as in defense litigation as well in that space.
Awesome. Well, thanks for joining us. I kind of want to go over a few different sections of this for people that may not be aware of. I want to talk initially about what the Unruh Act, so the regulations in the state of California. Then I'd like to go over a little bit with the DOJ and their announcement on March 18th with regards to ADA and websites being a part of it. And then some of the issues that you're seeing with current state of lawsuits, demands, services, and maybe errors that people are making to try and be accessible with maybe not the best knowledge or experience with it. So let's start off with Unruh, if you don't mind. Just kind of explain to people how Unruh started about 3.5 years ago and kind of what the ramifications are of the Unruh Acts, Section 51 and 52, with regards to website accessibility.
Well, just to clarify, the Unruh Act has been around since 1960s, so it's been around for a really long time. It actually, California was at the forefront when it came to really incorporating people with all sorts of disabilities, physical, cognitive, visual, hearing, it back into society. So California was really the pioneer, and then the federal government kind of kept caught up in the 90s. But with that being said, so under the Unruh Act, if you have any type of business, place of public accommodation, which is a privately owned commercial business that consumers can go purchase goods or access services to, then you have a responsibility to not only your brick and mortar, if you have one, to be physically compliant, but you also, and now in your digital space, have an obligation to provide effective communication under the Americans with Disabilities Act and the Unruh Act. And so there's been, split decisions here and there about what that looks like and what that means. But as it currently sits here in this state of California, it's generally known that if you're going to have a website where you can conduct business through it, purchase services, order something online, make an appointment, if there's any sort of interactive component to your website, then it needs to be created in a way that will be accessible with and compatible with screen reading technology and all other types of assistive technology. And so businesses have an obligation to know what that is. They have an obligation to make their website compliant, and they have an obligation to provide that service to the general public.
So, one common misperception I have, and I think it's because it's kind of a confusing area federally, is do businesses need to have 15 employees for them to have to comply with this law, or are there any parameters that protect small businesses against these laws and lawsuits?
So the threshold requirements for ADA are for employees. They're not for the general public. So under the ADA, if you have 15 or more employees, then the ADA applies to you in your employment employee context. That is completely separate from the public accommodation spectrum. So in California, under the DFEH, the Department of Fair Employment and Housing, which also regulates employment here, it's very similar. If you have 5 or more employees in the DFEH, discrimination laws attach to the employer employment relationship. If you are open to the public and you have one customer or one potential customer, the laws apply to you as it relates to that customer. That's a completely separate issue for employment.
Awesome. Thank you. Now, I know it's been pretty, it wasn't maybe publicized as much as I believe it should have, but in my realm, it's been pretty significant that on March 18th, the Department of Justice officially put in writing that websites are part of the Americans with Disabilities Act. I know we've seen lawsuits quadruple in the state of New York. What have you can you talk about maybe that statement, that introduction to the people, and kind of what you've seen from that federally with regards to ADA website lawsuits?
Yeah, so it's an interesting relationship with website accessibility in the Department of Justice. So the Department of Justice back in 2016 was really thinking and putting into the proposed regulations website accessibility, and was really homing in on the WCAG standards as part of what they constitute accessibility. Legally, that never went through, so it's now those proposed rules are not active anymore. So the Department of Justice doesn't have an official guideline as to what you need to do in order to be compliant. But of course, not surprisingly, they have filed amicus briefs, which are friendly briefs for website accessibility issues all throughout the country. And their position has been for years that in order to provide accessibility or accessible web content, that has always been part of the ADA, because the ADA, since its inception, has always considered effective communication to be part of the business owner's obligation to provide access. And so under that effective communication umbrella is website accessibility, right? So they've had that position legally for years. They just have never had a specific statement that people can truly go back to of, okay, here's the official position of the Department of Justice. And I believe it was last year, maybe it was the year before, COVID timelines, everything was a blur. But the House of Representatives sent a letter to the Department of Justice saying, please, for the love of God, will you please give us guidelines so we can help our businesses comply? Because we've got split state decisions, split district court decisions all over the United States. There's not a universal rule. And the DOJ came back and said, yep, accessibility is important, but it's up to the business owner to figure out how they want to provide that service. So they said everything but nothing at the same time. So at least they're now clarifying their position. But again, there's still no specific guideline established that says this is what you need to do in order to be accessible, which is really frustrating for businesses, because a lot of businesses, it's very expensive. It can be very expensive to redo websites. If you've got a complex website that's, has hundreds of millions of, clicks per month, and you've got multiple pages with multiple services, to retrofit that website is going to be really expensive. And so a lot of businesses are like, well, there's no solid golden rule, so why would I do it? And I get that perspective. But the bottom line is that the DOJ is saying, nope, it's got to be a part of your business plan. You have to think of accessibility as part of the cost of doing business, just like you would have insurance or a business license. You would pay payroll for your employees. All of that is the cost of doing business. And accessibility really should be kind of wrapped up into that umbrella as well.
So, in your maybe opinion or experience, since we have a rule with Unruh, since we basically have case law that for years has stated WCAG, whatever the current version is, AA standard, since law 508 federally references WCAG AA standard, would it be too much of an assumption to believe that at some point they're going to copy those rules from 508 and throw it over to ADA? Or what think will happen, or how that will shake out?
I think at a minimum, it's going to start there. I think they're going to start there and mirror the Rehabilitation Act. And just so people understand kind of what the difference is, the Rehabilitation Act is for any entity that receives public or state funding, so federal or state funding. So if you're receiving federal grants to operate your business, there's a question of fact there as to whether you need to be complying already with the Rehabilitation Act. And certainly that applies to any government entity or anything like that. But no, I think that is where the DOJ will start, is to already kind of just mirror what's already existing. And then as they kind of get their bearings, expand on that. And I think it's going to be more onerous on public accommodations to even provide more accessibility. So while the while the Rehabilitation Act may stay at WCAG 2, AA standard, as the the guidelines keep coming out and those guidelines keep changing, I wouldn't be surprised if the DOJ says whatever whatever the World Wide Web Consortium says is going to be what the new standard is. And I think, that's my fear, because it changes, it changes. But I think at a minimum, it's going to mirror those Rehabilitation Act standards. Absolutely.
When you bring that up, I'd forgotten about this. I believe it was the same month that they edited the Unruh or amended it to cover this. There was also a state law, I think it was like AB 1432 or something like that, that was along the same lines, that if you're getting money from the state of California, that you must adhere to those standards. Have you seen any enforcement with that in the last 3 years since that went into effect in January of 2018?
I haven't. And I think it's the same problem as the ADA, right? There's no enforcement agency. It's not like the IRS is going to be on your back when you're not paying taxes. There's no enforcement agency here like that, a similar agency that would go out and enforce that. What I do know is that for the California Commission on Disability Access, they're really they're not a watchdog by any means. They don't enforce anything or whatever. They're more of just kind of a think tank and a knowledge bank. But I know that they're very, very concerned with, in the construction related access space, of people not reporting settlements, they're not reporting cases, that sort of thing. And they're required to do that. And so I wouldn't be surprised if eventually this falls in the California Commission on Disability Access's lap, kind of having them patrol that in some way. But as far as enforcing it goes, I haven't seen that at all in the litigation field.
I haven't either. I just thought about that once you brought up the federal law. Let's talk a little bit about a frustrating part from my aspect and a frustrating part from customers that I speak with around the country who use these quick fixes. They're called overlays, little things where you have that little symbol on your website somewhere and it clicks up and does something. Because I deal with clients on a weekly basis that their web person, their marketing person, someone has said, hey, put this on there. This will make your site accessible. And then they ask me, why did they just get sued with this? So can you kind of talk about your experience with overlays and what you're seeing in the courts right now in the summer of 2022?
Well, overlays and widgets are really, really fascinating because they really advertise heavily. People are heavily relying on them. I've seen national companies relying on them. And now what we're seeing here in the litigation field is about 13% of all lawsuits filed specifically target websites that have overlays on them. And the reason is because it actually frustrates the usability even more so. And overlays only deal with the screen that you see. It has nothing to do with the coding content in the background. So there's nothing that the overlay will do to actually recode or re-embed coding that will be compatible with assistive technology. And so it may brighten your contrast, may enlarge font, but that can also, because it's not done correctly, really interfere with assistive technology that relies on accessible coding to be useful. And so not only are we seeing a lot of litigation based on those overlays, I'm also seeing several times now in settlement agreements where plaintiff's counsel is saying, if you use an overlay, that will constitute a breach of this agreement. They would rather you do nothing than use an overlay most of the time. And while there may be very limited circumstances where, if you've got a really small budget and you're trying to figure out how you're going to make this accessible, if you use it for a month or two to do something, okay, all right, I'll give you that. I think that shows your ability to try to do what you can based on your budget, but it is not, and I cannot be more clear, it is not an end-all be-all solution to the problem. It makes it worse. In fact, there are several companies, nationally known companies, who do website accessibility that have taken very strong positions against it, not just to boost their business, but because they've actually gone through the analysis with that overlay on the website and can demonstrate specifically what makes that particular website worse for accessibility with an overlay. But also, the National Federation for the Blind has specifically come out because Accessibility a couple of years ago wanted to be a sponsor for their national convention. And on their website, it's still up. The board of directors has specifically called out Accessibility, which would mean that would trickle down to every other overlay. It's not just them. I think the heart of these companies is really good. I think the desire to make websites accessible is a beautiful thing, but it falls short. And so the National Federation for the Blind has basically said, you don't take into account any actual person with a disability uses assistive technology. So we are not going to allow you to endorse our national convention. And I think that in and of itself speaks volumes, because you can't have accessibility without a live user component. It doesn't make sense. An automated scanning tool and an automated overlay you cannot replicate that with the human experience. You just can't. It doesn't work. So, and you're supposed to be making your websites accessible to humans, not to an automated scanning tool. So they're very problematic, very problematic.
Well, and I've seen some sites where they're trying to say, click this button to go to an alternative site. And I think what some people kind of miss maybe with the law is this is about inclusion, not segregation. So you have to make the website so that it works for everyone, not send someone over into a corner with an abbreviated version of a website so that they can see it. Is that correct?
Yeah, I mean, there's some gray area there, but it kind of goes back to the whole separate but equal argument, right? That's obviously not allowed in the built environment. And so while I haven't seen any cases that specifically prohibit that from happening in the digital environment, I wouldn't be surprised if that doesn't happen soon. And I think that there's an important part of maybe staging website compliance, because as I stated earlier, there may be a website that's incredibly complex, and you're now realizing, okay, I have a colleague of mine and she's a brilliant attorney, and her website is insane. It's got hundreds of pages, so much information, and it's been accumulating over the last 25 years since she's been practicing law. And now she's looking at it as like, well, wait, do I even really need all this information? Is this even really helpful? And so while she's going through that process, it may be important for her to create a new website accessible and then filter in information as she kind of offsets and offloads information on the other site. So again, for an interim solution, you get to brainstorm and you get to do these different ideas. And sometimes there is no other choice other than to do some sort of portal or some sort of alternative website. But that shouldn't be your go-to ever. That should be an absolute last resort. And you should really be working with counsel to determine if that's an appropriate response, and working with your website development team and your auditing team like Glenn to really make sure that this is literally the last thing that we can't do anything other than this. And you've got to be able to document to show that that's reasonable, but with the caveat that a law may come out, or a case rather may come out and say, no, we're not going to allow that to be sufficient. So it should be, if you are doing that, it should be very much used with caution and with careful consideration and planning. It is not the first step at all.
So with all this excitement then for the last 3.5 years of Unruh, the last 4 or 5 months of DOJ and ADA, what are you seeing as far as current state, current volumes? I know in New York, we've seen lawsuits go up 400% since the DOJ made this announcement in March. I believe I read in California that there were 18,000 lawsuits in the first 3 years of Unruh. What are you seeing kind of volumes, consistency, or maybe trends within lawsuits here in the summer of 2022?
Plaintiffs' firms are very, very aggressive. They've always been very aggressive, but this has really lit the fire underneath them to really be aggressive. So just for example, I have three separate clients, all based in California. They have no headquarters anywhere else. They have, one client had zero, I think there was like maybe 1 or 2 sales total of their company in Pennsylvania. The other client that I have is less than 2% of their sales is in New York, and they're getting sued by these out-of-state plaintiffs. And if you're doing business internationally on a website, it's going to be very difficult to challenge jurisdiction in New York, Pennsylvania, because you're doing business there. So if you're a California company or a Nevada company or any other company in the country, and you're getting sued by some of these aggressive law firms in New York and Pennsylvania, you're going to have to find counsel in those states, or a California attorney who can represent you in both forums under a special procedure to really ward off these lawsuits. And the initial settlement demands that I'm getting from these out-of-town firms would blow your mind. Absolutely blow your mind, because they know the law's on their side.
Well, and let's kind of delve into that, finding an attorney, the proper attorney, because I dealt with a company in way up Northern California, further north than you, that was a small boutique for a clothing store. Didn't really have enough money what they spent for sales from their last website, and they were sued out of Pennsylvania early on, probably 18 months ago, is when Pennsylvania really started hitting it. And the attorney that she contacted there was of the opposite approach as most attorneys. That was, let's just wait and see what happens. I think the demand was $55,000 for that one. And you know as well as I do that the longer you wait for this, the more your fees and expenses are going to incur. So when we have states like Colorado that started in 2020, Pennsylvania 2019, 2020, and things like this, how does a business owner know whom to contact when it comes to an attorney, and how to handle this on an aggressive or progressive stance versus waiting around? Because you know as well as I do, the longer you wait, the more money you have to pay in plaintiff fees and things like that.
Well, if you're working with a company such as yourself, Glenn, if somebody's working with you, my experience has been every single website company that does this accessible work has a list of trusted attorneys. So that would be the first call that I would make is, thanks for helping me with my website. Who do you recommend? Because you're working with somebody, you worked with somebody. Who do you recommend? And so that's certainly a really great place to start. Obviously, that's the work that I do. But I am not licensed out of state. I have to do the two cases now are still active in New York. I have to come in and especially appear under a special procedure. So, and I can only do that for a few times. It's not like I can regularly practice in New York because I'm not licensed there. So I've got maybe 3 times total. So that means 3 cases total. So what I strongly recommend is for them to contact the person that they're working with. And if they have questions, or, if you don't know anybody that can assist in that space, certainly they're, like myself, I can find somebody for you that does it. Because the last thing that you want to do is get in, especially in this website space, with especially how fast it's evolving, to get into, let's say, your run-of-the-mill employment attorney who's just, big firms throwing this to their employment counsel. It's a completely different animal. And so really finding somebody that specializes in this, there are referrals out there and we can get you names. So reach out to you, Glenn, reach out to me directly. And if I can't help you, I can certainly find you somebody that can, because it's really important to find someone in that kind of has built out a niche in this area, because it's very nuanced.
Yeah, I think it's probably worth an hour or 2 of your time, even if you're not licensed in an area, just to help do that interview process to make sure that the attorney you're going to hire in Colorado, Pennsylvania, New Jersey, Massachusetts, Illinois, all the places we're seeing these lawsuits start to uptick, because it's going to save you a lot of money in the long run.
Right. And I can't stress enough, don't wait. I mean, one of the cases that I had with an out-of-state defendant, I got on it right away. It was a client that had hardly any money. They had already taken, loans out to make payroll. They were really struggling. And I was able to present all that, information to opposing counsel before they even filed. It was just a demand. And it was a draft complaint. And we were able to resolve that for an incredibly nominal amount. That's a unique situation. I'm not saying that's everybody's situation. I'm not saying every plaintiff's counsel is going to respond that way. But if I had waited for them to file, that would have grossly inflated the potential settlement. And that would have been a disservice to my client. I mean, they just didn't have that kind of money. And my job is to help them. My job is not to pad my own pockets. They gave me very clear directive, and they said, this is our budget. Can you do it? And I said, I don't know, but I'll try. And thankfully it worked out, thankfully. But so I can't stress enough to be proactive with website compliance to begin with, but also if you receive a demand letter or complaint, don't bury your head in the sand. It is not worth it.
Yeah, I know. And especially until we get a little bit more, I would say, definition from the federal government, until we get all of these different districts of the federal courts on the same page, because everything varies. To the best of my knowledge, in the I think it's third district in New York, from the date you're served, if you fix the site in 30 days, aside from the fees and the penalties or the attorney fees associated with it, basically that suit kind of goes away. But that clock starts ticking and it moves rather quickly, especially if you have a complex site to try and get it corrected in 30 days.
Mm-hmm. Yeah. And as I just said, proactive compliance is really the only way. And let me be very clear. Plaintiffs may demand perfection when it comes to WCAG compliance. The courts don't. So it goes into, what are you doing? What is your budget? What's your plan? When did you start? What types of things have you already done? All of that comes into play of, this is an ever evolving area of law. We've been working towards compliance for months, and we're working on our budget, and here it is, and here's our plan, and this is what we've done, and here's all the people we've contacted, and here's who we've hired, and this is how many audits we've done, and yada, 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 yada. That is you're going to have a very hard time convincing a plaintiff's counsel that that's not reasonable. And if you can't convince them, a judge is certainly going to look at that a lot more favorably than they would if you just have done nothing and waiting to get sued. So it's not wasted effort. It's really not. It's really important to get in front of it, and to continually to get in front of it. Just like you renew your business license every so many years, you need to be looking at your website every so many years, every so many months, sometimes every quarter, because it depends on how much you upload, how much the business owner has a control of. If the business owner has a lot of control over the website, you need to be auditing that website constantly, because as soon as you upload something, you could potentially be taking it out of compliance. And so you need somebody to go through that process with you, or to train your team, to teach them how to do it correctly. So that way you don't spend all this money on a website and then you put your grubby hands on it and ruin it, and that happens all the time. So it's really important to have a true team that is constantly engaging in that ongoing maintenance process. And, as the rules change, the website needs to change, period.
Yeah, you're preaching to the choir. I can't tell you how many conversations I've had this summer with people that are saying, well, I do all this to my website. Well, I understand that you do that. But, is that process, are you going to take the time to understand all the little I's to dot, all the T's to cross? Are you going to understand semantic HTML? Are you going to understand ARIA HTML? I know you're used to doing this and you want to control that because you're a business owner. I'm a business owner. I'm a control freak as well. But sometimes it's better to evolve than to have exposure. And, you've seen as well as I have, you have the Liquid Lounge that was sued over one PDF. Domino's got hit with one little BOGO offer. I mean, when they're looking for places to sue, it's easy to find. And if you're not being very astute, very proactive, it's easy to have exposure.
Well, and you got to think about it, for a business owner, I'm a business owner, you're a business owner, right? You have an accountant, you may have legal counsel, you may have, somebody that does your bookkeeping, you may have different people with different roles in your company. It's, if you're a small business owner, yeah, typically you do it all yourself. I get that. But globally speaking, you can't be good at everything. You can't be successful at everything. You have a business because you're successful at this thing, and you're really, you provide this service well and you do this thing well, but hopefully you're offloading some of the responsibilities that you're not cut out to do. So just as, you know, for me, I would never prepare my own taxes. I just would never do that. I would royally screw it up, and I would probably be in jail because I would be awful at it. So I hired an accountant to do that. The same thing when I created my website, I wanted to make sure that it was accessible. And so I was able to find someone to, sorry, Glenn, it wasn't you. I apologize about that.
You're fired. We'll talk about that afterwards.
we worked out a trade deal. So it, you know, it worked itself out, but I knew that there is no way I'm going to throw up a WordPress website on my own and make this accessible. Absolutely not. I created a logo with somebody that was doing accessibility, all of that stuff. That's not my wheelhouse. My job is to practice law. I don't code. I don't create a website. I'm not a website developer. You know, just as I don't do SEO, I don't do any website stuff. So why am I going to take control over that? It doesn't make any sense to me. So in that type of space, you really need to think of it as I need to hire somebody that's a professional that can do this for me, or that can come alongside my team and walk them through this, and then periodically check in with them every quarter or what have you. There's really no other way to do it.
Yeah, I think it's going to be interesting as they get everything shaken out in DC, because if you look at 508, every business is supposed to have a compliance officer, which we become the business's small business ad hoc compliance officer. So we know how to talk the talk when they're needing to contact you because maybe someone sued them for a site that is accessible, but they're just throwing mud at the wall to see what sticks. So I think it's important for every business that's talking to their web team, their development team. You know, do you have someone that understands and is ready to put their kind of business on the line, their name on the line as well, to be your compliance officer, to work as a team and not just a vendor?
Absolutely. One of my clients right now, she's been working on accessibility for months and then got hit with a lawsuit last month. And she's very involved with her web development team along the way. She doesn't do it. You know, she's not doing the coding or anything. She's like, if I'm going to be paying you a certain amount of money a month, I want to know what you're doing. And that's really, I mean, that as a business owner is what your job is, right? Like if I'm hiring out to go do this work, I need to know what it is that you're doing. One, so I can make sure that I'm getting the biggest bang for my buck. And two, so I can understand the nuances to the best of my ability about what's happening here. And so literally she got hit with this lawsuit, and she just sent me a whole bunch of information from her web developer right out of the gate of here's what we've been doing for months, long before this plaintiff ever came here. And what do you need me to do? I'm like, great, let's go to trial. You know, I mean, this is a defensible case, and I don't think it'll go that far. I think it will get resolved by a motion before trial, but she's got her defense lined up and ready to go. So it's, if you're not going to settle out plaintiff for a very nominal amount, we're going to go and we're going to make you fight hard to support your position, because this is not a case that you're likely going to win. And that's the best position to be in. You know, that's really, that's where you want to be, is confident in, yeah, we're going to take this to trial and there's a really good shot that we could win this. So yeah, that's the important part.
Well, and I think the severity of importance to work with an attorney that does this all the time, to work with a web development team that does this all the time, is having experience with case law, because there are different rules within the federal government and within the state of California that you may be able to have something on your site that's not accessible if it's detrimental to your business. I mean, California has done this a lot with ordering systems for restaurants and stuff like that, to having alternatives for people with disabilities and stuff like that. So it is a very specific niche that if you have the attorney and a web person that can work together to help guide you down the road. So if you do receive a lawsuit from some of these serial plaintiffs, you can have case law that says, yes, this is what's going on, but we did this to accommodate. So hence, then we can have something else for someone that's cited.
Right. Absolutely. And the bottom line with the Americans with Disabilities Act and the bottom line with the Unruh Act is providing a reasonable accommodation. That's your job. So what's reasonable is arguably you, defendant, get to decide that. You need to take into consideration the disability of the user, but the law recognizes that what may be reasonable for the vast majority of this particular, population may not be reasonable to this particular plaintiff. And so you have to go through that exercise of, again, like I said, it's not, the law doesn't require perfection. The law requires that you do what you can when you can with your budget, because there's an entire analysis that goes into whether something is reasonable or not. And so if you can show this is what we've done because this is what we consider to be reasonable, and it accommodates 90% of the population, then that's going to be considered reasonable. I don't care if this plaintiff is super picky. I don't care if this is their preference. The law doesn't cater to this person. The law caters to what's reasonable for the vast majority of the population. And so that's an exercise that you would go through with your website developer, a competent one who understands what would be considered reasonable and what will accommodate the vast majority of the people in that space. And that's your job.
Excellent. Well, thank you very much. I think this is helpful. I hope we can do this on a regular basis just to kind of keep the average business owners informed, educated, so they kind of know what to expect. And like you have preached several times, being proactive versus reactive is always in their best interest. If anybody would want to reach out to you, what's the best way to do so, Rochelle?
The best way is to email me. So my email is Rochelle, RACHELLE at Golden, which is my last name, GOLDEN, A, D as in dog, A, defense. So that's DEFENSE.com. So it's Rochelle at goldenadadefense.com. And my website is goldenadadefense.com. So.
Well, thank you very much for volunteering your time. I hope this was helpful for people that saw that, and we will keep in touch with you from time to time. Have a good day, everyone.
Thanks so much, Glenn. All right.
Thank you.
Bye-bye.